Welcome back to part 3 of our RPA training. We are now on page 11 of the RPA, and we're finishing off on paragraph 14E. Now this whole section that you see here, so important, and that's why I didn't want to end the last training on this section. There's so much going on right here. Really important stuff, and this is where we see so many arguments between agents on how to proceed when we get stuck, we get in trouble, when contingencies are not being released, when escrow needs to be closed, and when your client is saying, hey, you're not protecting my interest. Most of that's happening in this section right here. So I wanted to start off, we're going to start off real heavy today, but I wanted to start off on this so that your brain was still kind of fresh. Okay, so I talk a lot about the importance of the notice to perform. So this is notice to buyer or notice to seller to perform. So what does this mean? Well, as you get close to the end of your contingency periods and you're trying to get people to remove those contingencies, if they don't want to do that, the question becomes, what mechanism is in the contract that helps you enforce that contingency? Now remember, the contract is written probably 90% in favor of the buyer, which means that the seller has about 90% of the obligation to enforce the contract, right? Because most of those contingencies are for the buyer to remove, so the seller has to enforce that. So let's say you're coming close to the end of that contingency period and you send them a contingency removal form, but they don't sign it. So what do? So here you go. You send a notice to the buyer to perform. You can send, like, again, either to the buyer or to the seller, but let's talk about it to the buyer again because of that 90% enforcement on the seller. The notice shall be in writing, be signed by the applicable buyer or seller, so typically the seller who's enforcing it upon the buyer. Give the other party at least 2 days after delivery to take the correct action. A notice to the buyer to perform or a notice to the seller to perform may not be delivered any earlier than 2 days prior to the scheduled performance date to remove a contingency or cancel this agreement or meet an obligation as specified in paragraph 14 above. So what does that mean? Okay, say you have a 17-day physical inspection or a property inspection period. You can send the notice to perform on day 15, giving them 2 days to remove that contingency. So that means that on the 17th day, you can then cancel if they haven't removed it yet. You don't want to wait till the 17th day to send them a notice to perform, because then you're actually giving them 19 days. So so it gives them 2 days to comply, which is why you can't send it any sooner than 2 days before. And now, remember, so you can send it 2 days before, whether or not that scheduled performance day falls on a Saturday, Sunday, or legal holiday. Remember, if you have a contingency in place, or even the close of escrow, if that 17th day or that 30th day or whatever that number is lands on a Saturday, Sunday, or holiday, it rolls over to the next business day. So even though you know that 17th day is going to roll over to a Monday, and it was supposed to be on a Saturday, you still want to send it on the Thursday for the Saturday, and they will both roll over to the next business day. Okay, here's a key part. If a notice of buyer to perform or a notice to seller to perform is incorrectly delivered, okay, it's incorrectly delivered or specifies a time less than the agreed time, the notice shall be deemed invalid and void, and the seller or buyer shall be required, pull that back up, shall be required, here we go, sorry about that, to deliver a new notice to buyer or a new notice to seller to perform within the specified time frame, right? So that's why delivery of it is so key, because if you do it the wrong way, it wipes it all out and you got to start all over. You're starting over another 2-day process. Okay, moving on to the next paragraph, the effect of the removal of contingencies. So removal of buyer contingencies. If a buyer removes any contingency or cancellation rights, unless otherwise agreed, the buyer shall conclusively be deemed to have done the following: completed all buyer's investigations and review of reports and other information and disclosures pertaining to that contingency or cancellation right. 2, they shall be deemed to have elected to proceed with the transaction. And 3, assumed all liability, responsibility, and expense for the non-delivery of any reports, disclosures, or information outside the seller's control, and for any repairs or corrections pertaining to that contingency or cancellation right, or the inability to obtain financing. Okay, so that's what happens, right? If you remove your contingencies or your cancellation rights, these are the things that you're not necessarily giving up, but this is what is understood. Same with the removal of the seller contingencies. If a seller removes any contingency or cancellation right, unless otherwise agreed, the seller shall conclusively be deemed to have satisfied themselves regarding that contingency, elected to proceed with the transaction, and give up any right to cancel this agreement based on whatever contingency they are giving up. Okay, so that's your notice to perform. It's a great tool. We'll talk about this for just a second. As a contingency date is coming to a close, you deliver that notice to perform. If the other side is like, hey, whoa, we need more time, why are you sending that to us? What is their ability? Well, they can then send you an extension of time addendum, right? So if getting on the 15th day of a 17-day contingency, you send the notice to perform and they need more time, they're going to come back at you and say, hey, can we please extend that out to 25 days or whatever the number is. What this does for you, though, especially as a seller's representative, it gives you a space to negotiate terms or compensation for your client. So if they want more time, time is not free. What are you going to get in return? Is it going to be a per diem? Is it going to be a fee, a dollar amount, a repair, something, right? But it puts you in position to negotiate your giving of time for the receiving of something in return, right? There's a negotiation space there. So that's why it's so important to send those notices to perform, because you're putting your client in an advantaged position. Okay, let's say we get to the close of escrow date and we're not closing for whatever reason. And again, you want to be in position to stay in an advantaged place with your client. You send a demand to close escrow. Okay, so before the buyer or seller may cancel this agreement for failure of the other party to close escrow pursuant to this agreement, right? The date that they said they're going to close it. The buyer or seller must first deliver to the other party a demand to close escrow. That's the CAR form DCE. A demand to close escrow shall be signed by either the buyer or seller, whoever is making that demand. Give the other party at least 3 days after its delivery to close escrow. A demand to close escrow may not be delivered any earlier than 3 days prior to the scheduled performance date of the close of escrow. Okay, and again, if a demand to close escrow is incorrectly delivered or specifies a time less than the above time frame, the demand to close escrow shall be deemed invalid and void, and the seller or buyer shall be required to deliver a new one. Again, making sure we're delivering these documents correctly so we're not having to restart the process. Okay. Let's move on to the effect of cancellation on deposits. Again, a lot of arguments here, right? We cancel, what are we going to do with the release of funds, so on and so forth. So if a buyer or seller gives written notice of a cancellation pursuant to the rights duly exercised under the terms of this agreement, the parties agree to sign and deliver mutual instructions to cancel the sale and escrow and release of deposits, if any, to the party entitled to the funds, less fees, so on and so forth. So what's that important here? It's if you're canceling pursuant to your rights that are duly exercised under the terms, right, for the right reasons, if you can point out the paragraph to the reason why you're canceling, and it's in good faith and it's within the confines of the contract, the parties are agreeing already by signing the RPA. We're agreeing to sign and deliver mutual instructions. Okay? So when they say, well, I don't think I should give them the money back, They don't have a leg to stand on here, okay? So let's continue and read this a little bit further because I think this is really important here. A release of funds will require a mutual signed release instructions from the parties or a judicial decision or an arbitration award. A party may be subject to a civil penalty of up to $1,000 for refusal to sign cancellation instructions if no good faith dispute exists, right? So if you cancel it in good faith, there is no good faith dispute. And so, again, you could be subject up to a $1,000 penalty. And furthermore, like always love these little notes, neither agents nor escrow holder are qualified to provide any opinion on whether either party has acted in good faith or which party is entitled to the deposited funds. The buyer and seller are advised to seek the advice of a California real estate attorney regarding this matter. Okay, so we shouldn't be making the decisions, judgment decisions on whether or not we believe somebody canceled in good faith or not and where that deposit should go. Okay, that's a really big, heavy section right there, but unfortunately for you guys, this page does not get any easier as we move into paragraph 15. This was one I just had somebody come to me today on. The listing agent is having repairs done and didn't want to give up the receipts and show the buyer's agent who was doing the work, what kind of work was being done, how much was being spent on the repairs, so on and so forth, right? Whether or not they're bringing licensed people in or not. So, on the subject of repairs, repairs shall be completed prior to the final verification of condition unless otherwise agreed, right? Sometimes we do repairs after the close of escrow, but that's agreed. But otherwise, they shall be done prior to the final verification, which usually takes 5 days, takes place 5 days before the close of escrow. Repairs to be performed at the seller's expense may be performed by the seller or through others, provided that the work complies with law, including governmental permits, inspections, and approval requirements. Repairs shall be performed in a good, skillful manner with materials of quality and in appearance comparable to existing materials. Buyer acknowledges that exact restoration of appearance or cosmetic items following all repairs may not be possible, right? So if it was like a super custom job and that is like a once in a lifetime carpenter that did it and we can't find that guy anymore, it's not going to be perfect, guys. But it should be done in a skillful manner. I have a hard time saying that word. And with materials that are comparable. Furthermore, the seller shall do the following: obtain invoices and paid receipts for repairs performed by others. Prepare a written statement indicating the repairs performed by the seller and the date of such repairs, and provide copies of invoices and paid receipts and statements to buyer prior to final verification of condition. Now, why is that? The buyer is entitled to find out who was working on the property, what license they held, what warranties they give against the work, etc. So we want to make sure that we do that. So we talked about repairs up to the final verification. Now we'll talk about the final verification, the VP, right? The verification of condition of property. Buyer shall have the right to make a final verification of the property condition within the time specified in paragraph 3J, 5 days before the close of escrow. Not as a contingency of sale, guys. Remember that. You can't go in and say, oh, because of what we saw at the VP, we're canceling and getting our money back. No, it's solely to confirm that the property is maintained pursuant to paragraph 7B, which is, remember, if we go back to 7B, one of my favorite paragraphs, that's the property is in as-is condition unless otherwise agreed, and then at the time of delivery of possession, the house will be maintained, landscaping, the interior all look the same, debris, personal property removed, so on and so forth. So, property is to be maintained pursuant to 7B. Repairs have been completed as agreed, and the seller has complied with the seller's other obligations under this agreement. So, what's important? It's not a contingency. Now, what does it say? If the repairs haven't been done, if it hasn't been maintained properly, then you could theoretically go back and negotiate an extension of time on the escrow. We might have to wait and close out a little bit further because the other side hasn't done their duty to keep the property as agreed in this paragraph here. Or it could be, again, another opportunity for a negotiation. But these are what the obligations that the seller has. Okay. All right. So another big section coming up here, and this one's going to be on paragraph 18. It's also a really big part of the buyer's representation agreement exclusive, the BRE, which is a form that I know a lot of people are scared of, and we'll do a separate training on that form. A fantastic form, but one of the biggest key takeaways of that is for everybody understanding what the scope of duty is. So that's brokers, agents, buyers, sellers, everybody has a job. What's important here is to understand that the scope of duty so a buyer and seller acknowledge and agree that the agent does not decide what price the buyer should pay or what price the seller should accept. The agent does not guarantee the condition of the property. The agent does not guarantee the performance, the adequacy, the completeness of inspections, services, products, or repairs provided or made by sellers or others. The agent does not have an obligation to conduct an inspection of the common areas or areas that are off-site of the property. Okay, the agent shall not be responsible for identifying defects on the property in common areas or off-site unless such defects are visually observable by an inspection of reasonably accessible areas of the property or are known to the agent. So that's when we do our agent visual inspection, our AVID. Okay, the agent shall not be responsible for inspecting public records or permits concerning title or use of the property. Those are things that the buyer or seller need to be looking at. They're public. The agent shall not be responsible for identifying the location of boundary lines and other items affecting title. We're not responsible for verifying square footage or representations of other information contained in investigation reports, the multiple listing service, advertisements, flyers, other promotional materials. The agent shall not be responsible for determining the fair market value of the property or any personal property included in the sale. And we shall not be responsible for providing legal or tax advice regarding any aspect of the transaction entered to by the buyer or seller. I mean, so there's a lot of stuff here. We're not responsible for providing other advice or information that exceeds the knowledge, education, and experience required to perform real estate license activity. Buyer and seller agree to seek legal, tax, insurance, title, and other desired assistance from appropriate professionals. So guys, if you are not having this conversation with your buyers and sellers, you are not setting proper expectations going into the contract, right? You are setting yourself up for arguments and for disputes, for bad reviews, for the lack of repeat business, a lack of referrals. This should be an entire conversation with your clients, right? Setting proper expectations. That way, when you're performing, you're overshooting what they expect out of you instead of underperforming. Okay, one of the other newer parts of the contract that has been kind of creating a lot of confusion is this whole section here. We're back in paragraph 3 on the grid, 3K23, this assignment request, 17 days after acceptance. What is an assignment request? Well, there's a few different things. We're going to scroll down to paragraph 23, and then we'll probably actually do a training specifically on the AOAA, which is the assignment request form. But it's here in 23. The buyer shall have the right to assign all of the buyer's interest in this agreement to the buyer's own trust or to any wholly owned entity of the buyer that is in existence at the time of such agreement. Okay, what does that first sentence mean? Okay, let's say I, Josh, buy a house, right? But I have a trust or I have an LLC or a corporation of which I wholly own that entity, right? Some kind of company or business that I wholly own. But even more so, so trust LLC, you find that a lot. LLC, I would have to question how much of that would work, because I would have to talk to about wholly owned, because a lot of times LLCs, exactly what they say, limited liability company, there's usually a second or a third person. So maybe if the original contract had both buyers on it, like let's say my friend Steve and I are buying it and now we want to move it to our LLC, but even more so, my wife and I are buying a house and we want to move it into our trust, right? It's a wholly owned entity. I have the right to assign it, right? So I can assign my personal interest to my company or to my trust, and that's not an issue. And we would use the form AOAA. There's a section on there that says we're transferring it from ourselves to an entity that we wholly own. Okay. But there are other kinds of assignments. Anybody who has been working with investors, that let's say you have somebody who's a wholesaler and they want to go in and lock up a home for value X, and then they're going to try to resell it to somebody else for X plus 20,000 or whatever, and they want to assign their ownership of that contract to the flipper that they're selling it to. That is also considered an assignment. But now we're not assigning to an entity that we own, we're assigning all of our, or a portion of, or all of our ownership to somebody else, right? So, let's continue to read here. Otherwise, the buyer shall not assign all or any part of the buyer's interest in this agreement without first having obtained the separate written consent of the seller to a specified assignee. Such consent shall not be unreasonably withheld. Prior to the assignment, the buyer shall disclose to the seller the name of the assignee and the amount of any monetary consideration between the buyer and the assignee. So why is that so important? Again, as we talked about with people that were wholesaling, they weren't telling the people. So like, so they would go to the property owner and, like I said, lock it up for let's say they locked up a house for $100,000, and then they were going to go sell it to a flipper for $140,000. The property owner wasn't being made aware of that $40,000 fee in the middle until it was too late, till the property was coming through and closing escrow, right? The money would funnel down, and maybe they would see a closing statement, right? So this is an instrument, right? A mechanism that's now in the contract that allows the property owner to see what kind of monetary consideration is going on between the buyer and the assignee. So it's more full disclosure. The buyer shall provide the assignee. So what does that mean? The buyer, right? Normally the seller gives the buyer documents, but now we have an assignee, we have a third party. So the responsibility of the delivery of those documents now falls on the buyer, not the seller. The seller's already delivered them to the buyer. The seller does not then have to turn around and deliver them to the assignee. The buyer, who's bringing in the assignee, shall deliver the documents related to this agreement, including but not limited to the agreement and any disclosures. If the assignee is a wholly owned entity or trust of the buyer, that assignee does not need to re-sign or initial all the documents provided, right? So that means if I buy the house and I go through all my disclosures and sign everything, and then I decide, I want to put this in my trust, I don't have to come back in and sign everything again because it's still me, okay? But if I'm giving it to somebody else, then it works a little bit different. So whether or not an assignment requires the seller's consent at the time of assignment, the assignee shall deliver a letter from the assignee's lender that the assignee is pre-qualified or pre-approved. And then should the assignee fail to deliver such a letter, the seller, after first giving to assignee a notice of a buyer to perform, shall have the right to terminate the assignment. So let's say I'm assigning to somebody else who needs to go. So if I'm assigning it to any third party, they either have to show proof of funds, right, that they have the cash available to close that, or if they're getting financing to do this deal, they need to show that to the seller. And again, if they don't provide, then they will the seller will have the right to send a notice to perform and terminate. So I don't know if it's in here, I don't see it, but on the AOAA it's clearly written that if the assignee is not the wholly owned entity, then that new assignee shall initial the first page of all the disclosures that the buyer has already assigned, right? So I'm a seller. I deliver my disclosures to the buyer. As the buyer signs all of the disclosures, then turns and says, here's an assignee. It's my responsibility as a buyer to deliver those documents to the assignee, and then the assignee does not go back in and sign it. They just initial the first page of each disclosure, advisory, so on and so forth, because you already have executed disclosures, and we don't want to mess with that executed disclosure. The assignee's initial on the front page of each one of those documents is their acceptance of those disclosures and advisories and so on and so forth. Okay, so that's this section right here. Again, we will go over the Form AOAA in a separate video because it's, again, one of those forms that if you're not really reading slowly and carefully, it's really easy to go like, wait a second, where am I? So we'll take care of that one here shortly. All right, we're going to move over here now to page 14 of the contract, another area where there's a lot of confusion. This section here where we have more initial boxes and we have language that's drawn up in boxes and a lot of bold and a lot of big black lettering. So a lot going on in here. Okay, so first, a lot of times I hear a lot of people using the wrong terms. They'll talk about, oh, you got to sign the mediation and arbitration area, right? Well, it's looking at the contract. Here's your arbitration here, and yeah, that's a signed spot. But here's your mediation here. And you notice there's no signatures or initials here in the mediation section. The actual first one up here is the liquidated damages, right? So what are liquidated damages? Well, it says here, if the buyer fails to complete this purchase because of the buyer's default, right? The buyer's default. Now, that doesn't mean that they cancel because of a problem with the property or the inability to get financing or the inability to get the appraisal to come in. This is like buyer's default. I've removed all my contingencies. I'm ready to go. Everything's good. And I just decide at the end, hey, I'm out. I don't want to buy this house anymore, right? That's kind of more of a buyer's default. The seller shall retain as liquidated damages the deposit actually paid. So if you're taking, if you have a listing and it's a $500,000 house and you accept an offer with a $1,000 earnest money deposit, if the buyer fails to the buyer's default, your seller is going to keep $1,000. That's it, whatever they actually paid. If the property is a dwelling with no more than 4 units, one of which the buyer intends to occupy, then the amount retained shall be no more than 3% of the purchase price. Okay, well, I thought you just said $1,000. Well, no. Let's say it's a $500,000 house. It is a 1 through 4, and it's going to be a primary residence. And let's say you put down, let's say you put down 10% on a $500,000 house. So you put $50,000 down as an earnest money deposit. How much do you get to keep? $50,000? No, you get to keep 3%, right? No more than 3%. So 3% is $15,000 on a $500,000 house. So this should give you, right, the difference between the deposit actually paid and 3% should really help you as a listing agent determine how much that EMD requirement should be when you're negotiating an offer, right? Accepting a $1,000 payment on a $500,000 house isn't, I should say $1,000 EMD on a $500,000 house isn't putting your client in the most advantaged position. Okay, any excess shall be returned to the buyer. So if you have a $50,000 EMD and you're going to go after this, you got this 3%, which is $15,000. The other $35,000 shall be released to the buyer. Release of funds will require a mutual signed release instructions from both buyer and seller, or a judicial decision or an arbitration award, just like we talked about earlier. At the time of any increased deposit, buyer and seller shall sign a separate liquidated damages provision incorporating the increased deposit as liquidated damages. There's a form for that there as well. So if you're doing increased deposits, then you want to get really familiar with Form DID. Okay, otherwise, it caps out at 3%, guys, of the purchase price. Okay, moving on to mediation. Mediation is not an option, right? You can't like decide to go to mediation or not. It is mandatory. When you sign this contract, you are agreeing, the parties agree to mediate any dispute or claim arising between them out of this agreement or any resulting transaction before resorting to arbitration or court action. The mediation shall be conducted through the CAR Real Estate Mediation Center for Consumers. There's a website right there. That's where you go find your mediator, or through any other mediator, provider, or service that is mutually agreed to by the parties. The parties also agree to mediate any disputes or claims with agents who, in writing, agree to such mediation prior to or within reasonable time after the dispute or claim is presented to the agent. Okay, that's pretty cut and dry. It's not like an optional. They can't just say, I don't want to go to mediation, let's just go right to court and start suing people. Okay, this talks about mediation fees. Let's see here. Okay, here's another important part. This mediation provision applies whether or not the arbitration provision below is initialed or not. Okay, so what does it mean to go to arbitration? Okay, so arbitration is essentially another process that's not going to be, in a courtroom with the judge or with the jury or anything of that sort. An arbitrator is somebody who is qualified to sit down and listen to both sides of the argument and make a decision. So the parties agree that any dispute or claim in law or equity arising between them out of this agreement or any resulting transaction which is not settled through the above mediation shall be decided by a neutral binding arbitration. The parties agree to arbitrate any disputes or claims with agents who in writing agree to such arbitration prior to or within a reasonable time after the dispute or claim is presented to the agent. The arbitration shall be conducted through any arbitration provider or service mutually agreed to by the parties, or if you want to fill it in ahead of time, you can. The arbitrator shall be a retired judge or justice, an attorney with at least 5 years of residential real estate law experience, unless the parties mutually agree to a different arbitrator. Again, so somebody that knows what they are doing. Okay, and so what this is a different way of trying to solve these disputes without having to go to a full-blown courtroom and judge, a trial per se, right? So you're going to save a lot of money going this way. So I have seen a lot with one side or the other not wanting to sign this because not fully understanding what's going on here. We had the other day a seller who didn't want to sign or initial this section here. And so I called them and said, so wait, what you're telling me is if my buyer, if there's a dispute and we can't figure it out through mediation, you're saying it's okay for my buyer to just directly sue you and go straight to court, and we're not going to try to work this out in mediation, right? So we're just going to go right to the 10th level instead of coming here first. So this is the section on arbitration. Read it, understand it. It is a little bit more difficult to explain, but you need to explain this stuff to your clients instead of just telling them, yeah, you got to sign here and you got to sign here because my broker says you have to sign here and sign there. No, understand what you're telling them to sign. Okay, now we're getting towards the end of the contract. There's a couple of cool things that I think they added into the signature block here that I really like. If you guys remember, back up in the grid in paragraph 3C, it's clearly stated when the offer will expire, but again, it's going to be spoken about here again, that the offer shall be deemed revoked and the deposit, if any, shall be returned if the offer has not been signed by the time specified. Well, after it gets past the time specified in paragraph 3C, right? Usually 3 days unless you write it in differently. Here is kind of some language in here that goes back to conversations that have been taking place at the state level for a few years now, which is how do we know an offer gets presented? How do we know if an offer is being reviewed, right? How do we know that kind of stuff? And there, you can send a written request, but they don't have to answer it. And it can be very frustrating in a competitive market, right? And it even says right here, seller has no obligation to respond to an offer made. I get a lot of calls and say, you know, shouldn't they or don't they have to mark rejected? No, they don't. If they don't like your offer, what do they do with it? They let it expire. If it expires, it's no good, so you don't even have to respond. It's no good anymore. So how do you get around this part? You can make a request and to present the offer yourself. Say, you know, Mr. Listing Agent, I have an offer from my client and I would like to present it to your client. When you do present offers or set an appropriate time, you can do that at the seller's home. You can do that in a neutral third site. You can do it in the association office. You can do it wherever you guys agree that you want to meet. You can present the offer yourself. If you're concerned about that offer being presented, again, the seller has no obligation to respond. So, first big key point here. Okay, another part that's really cool. If you're not familiar with what an RCSD, okay, RCSD is the Representative Capacity Signature Disclosure. It is the document that talks about who is signing on behalf of a trust, a corporation, a power of attorney, right, an LLC, any entity, things like that. So before, there was always an additional form, and that form is still around because not all of the contracts and paperwork have this section now built into it. The listing agreement still is like it used to be before. You would need an RCSD. But what does this mean? You have to look at an entity as a person. So if a trust is buying a home, the trust's name is on the contract. If a entity, a company, an LLC or corporation is signing the buying a home, then that entity, that LLC or that corporation, is the printed name of the buyer, right? So if it's my my company, it's my company is the name of the buyer. But the trust, the corporation, the LLC, the entity doesn't have a signature. It's not, a human. It's a buyer, but it's not a human. But there is something in the bylaws or in the articles of incorporation or in that trust that tell you who the authorized signer for that company, that LLC, that trust, who that person is. Or in the case of a power of attorney, let's say John Doe is buying the house, but his brother Fred is the power of attorney. So the buyer, still John Doe, but now the legally authorized signer is Fred. Okay, so Fred signs. So you fill out this section up here now on entity buyers. Okay, if the buyer is a trust, a corporation, LLC, probate estate, partnership, holding a power of attorney or other entity. Okay, and you're putting the name of the legally authorized signer. So if that's the husband and wife in the trust, cool. If it's me as the owner of a company, my name goes there. If I'm the person who has been granted the power of attorney, whether it's general or specific, my name goes in here. If it's a trust, identify the buyers as trustees, right, or as successor trustees. If you're in the LLC, you put in here if you're a managing member or who you are, right, what your position is. So then, as on down here on the signature block, again, the signature is the signature of the signer. So if it was a trust, it would be my name here, the name of my trust here, and my printed name here, and then my title trustee would go here. If it was my company, it would be my name here, my company's name here, my printed name here, and then my position in the company. If it's an LLC, it'd be like managing member. If it was a corporation, it'd be like CEO, right, chief executive officer or whatever. So it's built into all of this now. Very, very cool feature. Another is the ASA. We have a lot of ASA stuff coming up. If you have more than 2 signers, you use the additional signer addendum. Don't cram all 4 people in up here, okay? You want to just put each individual person. Do not combine names. Don't put in here Bob and Mary Hernandez. It's Bob Hernandez and Mary Hernandez, okay? They're separate signing blocks. On the ASA, there's language in there that says that they sign this ASA and they agree to all the documents that come along with this RPA. They actually have a space in there for liquidated damages and arbitration for them to sign on the ASA as well. Okay, so acceptance of offer. Now there's actually some more work here for the listing agent to do. So seller warrants that the seller is the owner of the property, has the authority to execute this contract, etc., etc. Here we go. Seller's acceptance is subject to the attached counteroffer or backup addendum or both as checked below. So now you check a box here if there's going to be a counteroffer coming back. And then again, the same thing. If the seller is an entity, there's another Rcsd built in for them here. And then the seller sign here. Okay, and that's how you finish the contract. So we'll talk more later about all this, seller counters, backup offer addendum. Let's talk about backup offer addendum right now, because I had this conversation the other day. So let's say in this market, extraordinarily competitive, you have the second best offer. And, the listing agent says, hey, well, we'll put it in backup offer, right? And you're like, oh, okay, cool, we're in backup offer. Well, you're not, unless you do the work that puts you in the backup offer. So if they come back and click the backup offer addendum, that means they liked your offer and they're going to keep it the way it is. You execute the offer, but it's in backup position. And on the backup offer addendum, it tells you that you're in second position or third position or whatever it is, what position you're going to be in if they have more than one of those. They can check both of these boxes, seller counteroffer and backup offer. Let's say they want to work with you. They want to put you in backup position, but they don't like exactly how you wrote the offer and they want to negotiate some terms. So I know that sounds weird because now the seller is negotiating with more than one person, and that's the way it's supposed to be done. They're going to go with a different offer, but they want to put you in backup. You need to come to agreement on the terms of your offer, execute it, and then put it in backup position. Why is that important? Well, let's say the first party doesn't follow their timelines appropriately and the notice to perform has been given to them, or they decide to cancel or whatever. That first offer cancels. Now your offer, which has already been executed in the backup position, just automatically goes into yours. That becomes their cancellation date becomes your acceptance date, and the following day is day one. There's no need to go back and try to rework all this stuff and figure out what you're going to do about the expirations and of the offer, and do we have to rewrite it and all. And, oh, now we got to figure out terms. No, you get the terms figured out immediately, put it in the backup offer position. So if something happens to the first offer, you're already in position to move forward. So that's again, really important section right there. And the last page, right, this part right here is where we do the signatures now for the agent. What's different down here is that we have a couple different things. Okay, you have the cooperating broker commission statement in here. Seller's broker agrees to pay the buyer's broker, and the buyer's broker agrees to accept out of the seller's broker's proceeds in escrow the amount specified in the MLS, provided that the buyer's broker is a participant of the MLS in which the property is offered for sale or in a reciprocal MLS. Right now, remember, all of us brokers get together in the MLS and we all agree to exchange the commissions with one another through the MLS system. That's one of the main functions of the MLS. If the seller's broker and buyer's broker are not both participants in the MLS or a reciprocal MLS, right, there's some MLSs that have agreements with other MLSs, in which the property is offered for sale, then compensation must be specified in a separate written agreement, the CAR Form CBC, Cooperating Broker Compensation, declaration of license and tax, SCA Form DLT may be used to document that tax reporting will be required, and et cetera, et cetera. So what's important here, if we're not in the same MLS, if you're writing an offer on an out of area and we don't have an agreement, and we try to spread our agreements, that's why you see a lot of brokers have membership in multiple MLSs to try to get those agreements for you. If you do not, or you're writing in an area where we're not a participant, or the broker is not a participant, then a Form CBC should be sent along with it. Otherwise, you may not be entitled to the cooperating commission from the selling agent. So really important right there as well. When you sign here now, this is really kind of cool. You have the firm, and then you have the agent's signature and their license number. Okay, and then if you have more than one agent, you hit that box and the AAA pops up, right? The additional agent agreement. And then if there's more than one brokerage that's representing, right? Sometimes that happens. Let's say you got somebody out of area that sends you to a referral, but they don't want to give you like a straight across referral. They want to work the file with you. The brokers have to have an agreement that they're working that client together. That's Form ABA, Additional Broker Acknowledgement. That would pop up when you hit that box here. And then you put the email address that you want to receive correspondence, the text number that you will receive text messages from, and an alternate email. And then the same thing, the agent on the seller's brokerage firm, the agents, they have an area for a AAA, for an ABA, and then where they like to receive, this is to be filled out by the seller's agent as they're helping their client execute the contract. The seller's agent's email, their text number, and where they would like to be contacted, right? So that there's no like, oh, I didn't get it, you didn't send it to the right email, that's not my number. No, you're putting the information in here for how you would like to be contacted. And then just like before, if we come to agreement on the contract, escrow fills out this section here, and then there is a presentation of offer section here as well that should be filled out. But again, you're not going to find everybody doing that, and it really, I think a lot of contracts go to escrow without having that filled out. Okay, so that's the final page of the RPA. Part 3, I think we probably covered close to an hour and a half, maybe a little bit more, maybe closer to 2 hours actually, of contracts here. There's a reason why the contract is so big and bulky. These are massive deals that we're doing, people's lives, people's money, people's dreams. There's been a lot of arguments and lawsuits over this kind of stuff. Now, the best way to stay out of those, guys, it's to set expectations with your clients, really have those conversations about scope of duty that we talked about on this part of the contract. Setting expectations is huge. It's really, really difficult to let somebody down if you haven't overbuilt them up, or if they don't really know what you're supposed to do. If you're very clear with them on what you're gonna do and you deliver, heck, in that case, over deliver, right? Set the bar a little lower, jump a little higher, right? Don't set the bar so high that you always come in underneath it. That's huge. Secondly, read this thing. This 16 pages of stuff to read. Take the time. I read it on airplane flight. I've read it, you know, in the morning when I wake up, knock out a little bit, knock out a little more before you go to bed. When you have a little bit of spare time, when you're riding the exercise bike, read it. Read this contract. Make it your friend, right? I've said that at the very beginning of this training series, and I'll say it again at the end. The RPA needs to be your friend, and you need to be able to rely on it, right? You rely on your buddies and your friends when you get in trouble. You can rely on this. When your transaction gets in trouble, you can go, hey pal, help me out. And 99 times out of 100, the answer you're looking for is buried in this text, okay? And so understand the RPA. Blame things on the RPA. I can't tell you how many times we've had agents say, you know, so-and-so says this or wants to do that, and all I do is go back and I just go, hey, look, read paragraph 7B, read paragraph 25, whatever it is. Go back and read it. You'll find your answer there. And all you have to do is cut, copy, paste, send it to the other side and go, hey, I don't know. You said you think this, but this is what the contract says. So I'm going to just say, let's go with the contract on this one here. So make the contract your friend. Thanks for taking the time to watch the 3-part series. Good luck with your transactions. And as always, you know, reach out, give me a call. I'm here to help you.